I don't see Mr. Pinion on the line, is he?
So Mr. Pinion is here in 1D.
Okay.
Oh, and that reminds me, the pretrial conference that we have in the case on the January trial calendar is at 12:30 today?
Yes, I do believe. Let me look at the calendar again, Judge.
Okay. Okay. I think it's 12:30. Okay. All right. Well, Ms. Nelson, if you could try to figure out what's going on with Ms. Ackley, that would be good to get her in the mix. Is Mr. Henderson in custody?
Doesn't look like it. I don't see any booking information on it.
Okay. Mr. Pinion says yes. All right. Let's go to the next case. It looks like they're co-defendants. It's Darian Flores and Hallie Carlin. Who represents Darian Flores?
I do, Your Honor.
It is, and hello, Mr. Franklin.
Good morning, Judge.
Good morning. Thank you for joining us.
Yes, sir.
And then I have here that Hallie Carlin is represented by Mr. Rousey.
No, sir, Judge. Kevin Ryan. Mr. Rousey and I represent her together, but Kevin Ryan.
Okay, it's a tag team.
Yes, sir.
All right, so Mr. Ryan, you are one of, is Hallie Carlin, is that a female?
Yes, sir.
Ms. Carlin's attorneys. Great.
Yes, and she's here in the office with me, Judge, if you need to.
Pardon me?
She's here in the office with me.
Oh, Ms. Carlin is. Great. Good. Okay. Well, let's just get an update as to what's happening. Mr. Franklin, is Mr. Flores in custody?
Yes.
Okay. And is this a case where you've received all the discovery, or where are we? I guess this is sort of an update for everyone.
Yeah, the physical discovery I believe to be complete. Still working my way through some things, but everything that I would kind of look for on a checklist, I have.
Okay.
The thing I think that was kind of holding us up, so to speak, I have reason to believe that the co-defendant is likely to be having a conversation with the state. I think just for COVID reasons and a lot of the stuff that Mr. Pena is dealing with the transitions in the DA's office, it's just not been a good time for them to bang out a proffer or have a conversation of some sort. But from my initial reading of the case, before I kind of got wind of it, I expected it. And we're just kind of trying to let things settle before we, I don't want to go to a trial calendar without knowing the context for all the information.
Okay. I'm just looking now at the docket. It looks like not a lot has happened recently. There was a final plea in front of Judge Reeder a year ago, a little more than a year ago, around Thanksgiving last year, then again in the middle of January. We had a status hearing towards the end of February. I don't know what the result of that was, and then nothing until now. So
I know.
I'm assuming.
I don't want to. I'm sorry to interrupt. I don't want to say that the computer's wrong, but I felt like we had at least an inquiry or a conversation about the case at some point since February.
My guess is we did when I was looking for cases to put on the trial calendar. I probably asked what's going on with this case, but that would have been informal. In terms of coming into court or having a discussion, February 27th was the status hearing. I don't know what was discussed then, but in looking at the docket, I suspect if there were important substantive pretrial motions we needed to work through, that would have been brought to my attention. So I think I'm going to hear from Mr. Pinion, and I'll also hear from Mr. Ryan. Moving this to a trial calendar is the right next step. But I hear you, Mr. Franklin, that what that trial might look like depends a whole lot on what might happen with Ms. Carlin's case. I don't think that's a reason not to put it on a trial calendar. it's a reason not to say this is first out specially set if we haven't gotten a little more of a sense of what's happening with Ms. Carlin. And to your point, Mr. Franklin, that may be a little difficult to sort out as Mr. Pinion shifts his attention elsewhere in the coming weeks. But that's not something that needs to hold up Mr. Flores and Ms. Carlin for too long. Mr. Ryan, what's happening on Ms. Carlin's side?
Judge, my understanding through previous counsel, I apologize for my voice, Judge, through previous counsel, Ms. Love, and then Mr. Pinion took over when Ms. Love left, is we are cooperating and they want us to testify, and then we will resolve our case after the testimony of the trial for the co-defendant.
Okay. Mr. Pinion, I don't know if you're able to hear that. They're coming to make the system work. They claim we were not on their list. But is that jibe with what your understanding is, that the trial would be of Mr. Flores, not of both defendants? Okay. Okay. Mr. Franklin, were you able to hear that?
Not a word.
Okay, here it comes again. Mr. Pinion said his understanding is aligned with Mr. Ryan's, and Mr. Pinion said he fully expects that the state would be offering Ms. Carlin use immunity. They would expect to call her as a witness in the trial of your client, and that her charges would be resolved after the completion of the trial of your client. Which says to me, we got to get your client on a trial calendar, because the only thing that's going to change between now and then would be the execution of the use immunity agreement. Of course, you'd get a copy of that. That would be subject to discovery, et cetera. But it seems like there's not more Mr. Ryan or Mr. Rousey will be doing on Ms. Carlin's behalf, other than telling her to stay out of harm's way and to.
So am I correct in assuming that she'd be granted use immunity without an actual proffer? So there's not a statement for me to expect to receive about what she would be testifying about? She'd be receiving use immunity without a claim of what she's testifying to?
I don't know. That's a discussion for you and Mr. Pinion to have. Okay. The microphones are starting to come on in the courtroom. Were you able to hear that?
No, sir.
Okay. I think the defense microphone is on, but not the prosecution yet. What Mr. Pinion said is that Ms. Carlin gave a statement to the police. Hopefully you do have a copy of that. And he does not envision there being a second sit down with Ms. Carlin. There is her statement to law enforcement, and there would be her testimony at trial. That's as far as I'm going to go in terms of intermediary. The rest you can follow up with the prosecution on. But it does seem to me that the right next place for Mr. Flores is a trial calendar. He is on an aspirational trial calendar that Ms. Nelson is compiling, not publishing, but compiling for tax day, April 15th. I have no way of knowing if we'll be having individual division trial calendars that quickly. But if we are, the case would be on that trial calendar. If we aren't, then I will continue to work with you, Mr. Franklin, and Mr. Pinion's successor in this division to see when it would be appropriate to have Mr. Flores's case added to the bench-wide trial calendar that we're running, at least initially. But for now, it's not there for reasons that you've explained to me, Mr. Franklin. And we'll just keep the Flores-Carlin matter as one that ought to be on one of our first trial calendars that we have in this division if it's not addressed before then. Does that work for you, Mr. Franklin?
Yes, that's fine. So yeah, so if I understand correctly, we probably wouldn't be potentially reaching it till April is the sum of that.
So the soonest it would be reached if we just focus on this division would be if we have a trial calendar in April. This case is on it. I suspect there'll be others, and there could be some even older than this one.
Understood.
But it would be on that one.
Okay.
Whether it gets onto the bench-wide calendar before then, you are more of a gatekeeper on that because the lawyers need to agree that it's a case where their client who's been in jail for 2 years wants his trial. And by April, even if we aren't doing division-specific trial calendars, I suspect we'll have a few jury trials under our belts, and that may cause folks to think differently about whether they want to have cases added to that bench-wide calendar. And the only difference is because we're going to be limited to the first floor initially for jury trials, I can't be the only one who gets to do jury trials because I'm on the first floor. We'll share 1D and 1C with several judges. But it's a long way of saying, I think the next stop for Flores and Carlin is a trial calendar. I don't think we need to have another conversation about the case other than we're putting it on a trial calendar. And if something works out before then, let Ms. Nelson know. Otherwise, that's when we'll see you next on this case.
Yes, sir. I'll reach out to Mr. Pinion and bug him about whether it's worth me bugging him the rest of the year about the conversation.
Okay. Mr. Ryan, does that plan work for you?
Yes, sir, Your Honor.
All right. Well, Ms. Carlin, you are on bond. I don't have the bond right in front of me, but it's important that you continue to comply with the conditions of your bond, okay? All right. Well, that takes care of that one. Thank you.
Be excused, Judge.
Yes, sir.
Thank you, Judge. Happy holidays.
You too. Ms. Nelson, any update about Ms. Ackley?
No, Judge, she was sent an email and I resent that this morning, but I have not heard from her, any contact from her.
Okay. Mr. Pinion, without getting into any substance of the Henderson case, is the state ready for that to be tried, or is there something else going on? Okay. We'll get we'll get Ms. Ackley and you and me having a conversation about that. Okay. Ms. Hall, good morning.
Good morning, Your Honor.
Were you able to hear Mr. Pinion when he just spoke? I think all the microphones are on now.
I didn't, but I also was not listening. You're louder than he is, so he could have said something. I missed it. Maybe Mr. Pinion say something again.
It's very, I can't hear him.
Okay, Ms. Nelson, will you please reach out to IT and let them know that?
Okay, I will. It looks like his mic is off.
Well, I think it's supposed to be muted. If it's not muted,
okay.
We get bad reverb.
Okay, I'll reach out to him.
Thank you.
Thank you.
All right, well, let's keep pushing through the calendar. Position 4 is State versus Palmer. Ms. Patel, that is your case. Is Mr. Palmer in custody? Okay. All right. And this is this is supposed to be a final plea. I don't know how we're doing a final plea in this context if your client's not here and not on Zoom. Ms. Nelson, what was the thought about how we do final plea for Mr. Palmer? Oh, this is the case O'Neill and Palmer.
He was supposed to, Mr. Palmer, I thought was, Judge, that's my error. They were not brought over.
So we didn't tell IT and we didn't tell the sheriff.
No, sir.
All right. I'm not going to take any more of your time, Mr. Gaffney. I appreciate you dialing in. I thought Mr. O'Neill was going to be here. This was supposed to be the final plea date for him.
Judge,
It's going to be later.
I'll just give you a status, Judge, before I sign off. The case is in the exact same posture it was the last time we spoke, where we're still working through discovery issues. So I would ask that you reset it to your next final plea. And hopefully Ms. Hall and myself will have the identification issues resolved by then.
Well, you're getting a reset because your client's not here. Ms. Hall, what are the discovery issues that persist in this case?
The same issues we had last time, Your Honor. Ms. McCauley sent you an email this morning. This is something that we've been working on since our last final plea. The issue in the case is that apparently the case was assigned to 2 different case numbers. This is something that we found out this week. Ms. McCauley was over at APD last night, literally going through case numbers, trying to locate this case number because the original officer that worked up the case. So the confusion comes in where it was an accident and an armed robbery. The accident was handed over to the investigations, but everything was not turned over. That's why I have been having difficulties getting the discovery. I apologize to the defense, but being in court every week and trying to get evidence from an officer that's MIA is almost impossible for me. But I did tell you last time we were in court that officer gave me the sergeant's information so that I can locate this evidence. When I got that sergeant involved, the entire case went left. That sergeant got my supervisor involved, and now she's been involved for about 2 weeks, and we still don't have the evidence because we have learned that it is connected to another case number. She has gotten success with trying to get more information. She has located different CID individuals that were on the scene. She believes that we will have the evidence by next week. I gave you a time frame the last time that we were in court of 2 weeks because I believe that once I talk to a sergeant in APD, I would have the evidence, but I can't control these agencies. Looks like my supervisor can't either. But we are in the Palmer case coming up with a resolution or trying to come up with a resolution with Ms. Patel. I have not talked to Mr. Gaffney because there's nothing to talk about because I don't have any of the additional evidence. And I apologize for that. But yeah, it's a lot that's been going on with this particular case. But we do have, looks like we are getting to the bottom of it, Your Honor. But all this has come down to an officer that didn't handle the case the proper way.
Okay. We're having some progress, I think, with the technology here. Ms. Patel, I don't know why we're getting the reverb now, but what's the situation with discovery for your client?
It's, I believe Mr. Gaffney and I have been served the same stuff. There's just a lot that is currently outstanding. And so with that being said, what I have is enough for me to at least have a conversation with Ms. Hall about moving in a direction of potentially resolving the case before trial. I indicated to Ms. Hall that I had to subpoena some documents to provide to her. I sent that subpoena off yesterday. So that is something that I need to get to Ms. Hall. I also, last time we were in court, Your Honor, I spoke about having my client brought over at some point to show him the discovery. That might not be necessary anymore because I was able to show the videos to his family members. So it just depends on whether or not he needs to see it for himself. But Ms. Hall and I both have an interest in getting one of the main videos that's outstanding because it would show potentially and presumably my client with no firearm, which is ultimately in the direction of our negotiation would be important.
Okay, and I'm remembering correctly, your client was still inside the van that crashed.
Correct.
So there's some evidentiary issues for him based on that, but you're trying to mitigate or fully understand and demonstrate what his role was vis-a-vis Mr. O'Neill.
Correct.
Okay. Ms. Hall, were you able to hear Ms. Patel at all?
I could.
Great, so things seem to be working better. The reverb was my fault. I wasn't muted here. So I think we're good. And we did not send a request. So that's our bad, not your team did not drop the ball.
Ms. Kelsey?
Ms. Hall?
Ms. Hall? Please, can you speak to me?
Hi, good morning. Merry
Am I
Christmas.
louder, Judge?
I think we can you hear Ms. Hall or does it need to be louder?
I can hear.
Yes,
Okay.
I can hear.
I think we're good. All right. Thank you, sir. Sorry for that fire alarm. Okay, so Ms. Hall, I have seen Ms. McCauley's email now. She has your back, good supervisor. And she is optimistic that now that a lieutenant is involved, you may be able to get what you've been politely asking for weeks in the next week or so. My thought is we put this case, both defendants, Palmer and O'Neill, on a final plea calendar in January. Because then that gives, just in case the discovery doesn't pop out right away, a little more time to work this. And then we reconvene and we get Mr. Palmer and Mr. O'Neill brought over here and take care of things. Does that work for you, Mr. Gaffney?
Yes, sir, it does. And I look forward to talking to Ms. Hall after the discovery is complete. But she's right. There's no point in talking until we see what's out there.
Okay. Ms. Patel, does that work for you?
Yes, Your Honor.
Okay. So let's get this on a January calendar, please, Ms. Nelson.
Okay.
Yeah, may I-
May I be excused, Your Honor?
Yes, sir.
Thank you.
You're all done?
Yes,
All
sir.
right. So I will see you in one format or another at 12:30. Great. All right. Position 6 is Dante Buford. And that is Ms. Hall and a Rachel Berman.
Ms. Berman used to be with our office, but I'm not sure.
I'm looking it up to see. It's an old case.
Yes, it's an old case. It was transferred over from non-complex. He picked up a new case, and I believe that's why everything was transferred over.
Okay. So yeah, Rachel Berman back in 2017 had the case. So it was in non-complex until October of this year.
Right, when he picked up the CVAC.
Got it. So this is new to us. And we need to figure out who will be representing Mr. Buford. He has a second 17 SC case that is closed. All right. And then he's got this 20 CP. Ooh, aggravated stalking. Okay. So if Mr. Buford is with us on a case that ends in 9.
That should be my case.
Okay. What would you like to know about it at this point? I guess you need to meet Mr. Buford and figure out what's...
Correct. And maybe if it could be added to a plea and arraignment calendar at a future date, then I could have time to get the file from our office.
Yeah, I don't know that it needs to be arraigned, but we could put it on a status calendar or something. So it was a re-indictment of the other 17 SC case. That's why that's closed out. Then there was a judicial hold. He got picked up in March, it looks like, and then bumped here. So I don't know that he's been arraigned. So let's do that. We'll put him on a plea and arraignment calendar.
Okay. And he does have this unindicted aggravated stalking allegation. Ms. Hall, anything you want to add about Mr. Buford?
No.
Okay. You look forward to doing business with him. Then the last one for this morning is Norman Handy. Mr. Handy's been on the call the whole time. There's Mr. Handy.
Yes.
We need his lawyer, Max Richardson. So, Mr. Handy, I don't know if you want to reach out to your attorney to get him to dial in, but we cannot address the motion to suspend the balance of the sentence unless we've got Mr. Richardson here as well.
Yes, I just sent him a note. I can give him a call now.
Okay.
Send him a text. Let me give him a call now. He has not responded yet.
Thank you.
Good morning.
Good morning.
Your Honor, that's Ms. Boyd. She is the victim in the case that we're currently, Mr. Handy's case.
Okay. Good morning, Ms. Boyd.
Good morning.
Hey, Carl. I'm still trying to get him in his office right now.
Okay, thank you.
Okay, he's getting on right now.
Thank you.
Oh, okay.
Ms. Hall, while we're waiting for Mr. Richardson, our calendar this afternoon, does it have many cases that are going to be pleas, if you know?
No, please, Your Honor.
You think are they all in a position to have a final plea discussion, or it's going to be something other than final plea?
Position 1 was a potential PTI when we was here last time. So I believe that's what that's going to be. Position 2, I believe, can have the conversation for a final plea. But positions
3, 4, and 5 are all kind of connected.
Right, but 3 and 4, we had discovery issues on those cases. So I believe it'll be more of a discussion than a final plea. I do have discovery now, so it's not an issue of locating it, but I had to stand over the officers to get this discovery last night.
Yeah.
So we have it, and I was actually, since Ms. Patel is there, Ms. Patel, I wanted to let you know that discovery is waiting for you on the 3rd floor. I was texting you when Your Honor just spoke.
Okay, well, we'll cover that. I just was getting a sense of how long that calendar would be, but that's a helpful update. I know one of the cases is Ms. Hodges. All right. Mr. Richardson, can you hear us?
Yes, I can.
Great. Good morning. This is Judge McBurney. We are ready to discuss the matter of State versus Norman Handy. He is on the call. Hopefully he'll reconnect with us, but he was tracking you down, and thank you to Mr. Handy for getting you on. You have filed a motion, Mr. Richardson, seeking to have the balance of Mr. Handy's sentence suspended. We also have on the call Ms. Boyd, who is the victim in the case. So I'll be hearing from her, or at least Ms. Rolak, the victim witness assistance expert on the matter. And we've got Ms. Hall for the state. Let me tell you what I understand the posture to be, and then I'll let you take it from there, Mr. Richardson. Mr. Handy was sentenced by Judge Downs in January of 2017 to 10 years probation, 5 years of active probation, followed by 5 years of suspended probation. That second count was actually the third count of the indictment. It was a firearm offense and had to run consecutive. So it was a total of 10 years probation. Mr. Handy had to spend a bunch of weekends in jail as part of his probation. And Judge Downs included as a special condition of probation, it's really not a special condition, but it is a notation on her final disposition, the following language: balance may be suspended after 3 years compliance and completing conditions. And I think that's the language, although you're going to correct me if I'm wrong, Mr. Richardson, that's the language that you're pointing to as the basis for your motion, which would be to suspend whatever remains of those 5 years of active probation. Of course, we've got the additional 5 that are layered on as already suspended. And in your motion, you've demonstrated that Mr. Handy seems to have done pretty well on probation and that he's already on non-reporting status for the Department of Community Supervision because he is a probationer who is low maintenance, doing what he's supposed to do and staying out of trouble. So with that context, Mr. Richardson, why don't you give me the defense perspective on this?
Can you hear me, Judge?
I can. Could you hear me?
Yeah, very, very well. First of all, I apologize for coming on late, but my intern who just passed the bar, which we're so happy about, also had some bad news that she just also tested positive for COVID. So it's just kind of been a rock and roll morning, and I've been trying to support her and her family. So anyway, with that said, just forgive me for coming on late. I take pride in being timely. I take pride in doing what I'm supposed to do when I'm supposed to do it. So that's my reason for coming on late. But I think the court has pretty much explained and summarized and hit on all the points that were expressed in my petition. Again, this young man has been in total compliance with the court and with probation, as far as I know. I think he would be an excellent candidate for easing the probation office's load. We're going through a lot right now, especially with this crazy virus going around. And I think that Mr. Handy has proven himself to have been rehabilitated. I think he's proven himself to be trustworthy and responsible in what Judge Downs had ordered him to do. And so for that reason, I'm asking the court to suspend the balance of his sentence, please.
Okay. Mr. Handy, couple questions for you. Are you working right now?
Yes, I am.
Doing what?
I'm an IT consultant.
Okay. And tell me what the burden is for you to be on unsupervised probation. Well, let me pause for a second. Ms. Crawford, Officer Crawford, thank you for joining us this morning. What do your calculations show as to the status of Mr. Handy, meaning unsupervised or not, and then how much time remains?
Judge, he's on unsupervised probation right now. He's in compliance and he only has 1 year and 1 day remaining.
1 year and what?
1 year, 1 day.
Okay, wow. We're almost to the 1 year mark starting tomorrow. Thank you so much.
You're welcome.
So Mr. Handy, articulate for me the burden for you of being on unsupervised probation for 1 more year so that I can understand the benefit that you would get if I granted this motion.
So one thing that I do, I am an IT consultant and director. With this on my record, I'm unable to take on certain contracts. So out of 10 contracts, I may be able to get 1 because of it's being on my record. So my income has been reduced substantially. Where I was normally making $125 an hour, I am settled to make $45 to $65 an hour right now for the work I can do. So once this is suspended, I can go back into the real world with the Big Five, IBM, Cognizant, the people that I've been working for, and they're waiting on me. HP, they're waiting on me to come back, and they understand what I'm going through right now. And once this is over with, then I would go back to work with those companies.
Mr. Handy, your understanding is that if your status were changed to being on what would effectively be a suspended sentence rather than a probated sentence, that would be sufficient for IBM and Hewlett Packard and others to be able to work with you?
Absolutely, and I have the emails. They're waiting on me.
Okay, so I just want to make sure I'm understanding the scope of the request. It's not saying close out the case because you got a first offender sentence, and it was a 10-year first offender sentence. Closing it out now is different from saying, let's move it to a suspended status. And you believe, based on representations you've received from these potential employers, that you could work for them if you were on a suspended sentence as opposed to an active probated sentence.
I think what I'm hearing is that if it's suspended, it's not on my record anymore.
Not saying anything to that effect. I don't know what's on your record and what's not. I'm not the subject matter expert here, and Mr. Richardson may jump in, but I understood the request for relief to be, could we please suspend the balance of Mr. Handy's probation, which is 1 year and 1 day, or by the time the order goes into effect, it would be 1 year. So could that 1 year be suspended? Of course, you've got 5 more years of suspended sentence beyond that. That was part of Judge Downs's original sentence. That is a different request from, could you please make my case go away altogether, which might involve something more significant than suspending the balance of your probation. So maybe I should turn back to Mr. Richardson and he can let me know more specifically the relief he's asking for on your behalf, because I want to be clear. I don't know what gets things off your record. I'm not making any representation that if I were to do one of these things versus the other, that it would get something off your record. That's not an area that I work in.
In response, Your Honor, and I did not have the pleasure of representing Mr. Handy at his hearing in front of Judge Downs, but I will represent to the court that my experience under a first offender plea, my experience tells me that it will reflect on his record that the case was in fact dismissed under the first offender statute. A lot of individuals are under the impression that once they complete a first offender sentence, that everything is expunged and there's no identity of that offense that was committed. But there is a notation on his record, on his GCIC record, that indicates that the case would be dismissed, and it was dismissed under the first offender statute. What I was asking this honorable court to do is to dismiss this case early under the first offender statute. And I don't know what the potential contractors are looking at, but if they would look at his record, they would see that the entire case would in fact be dismissed, and that he's no longer under probation. He's no longer under any kind of commitment or obligation to the court, and that the incident that occurred back there in 2016 or 2015 is behind him, and he has satisfied and complied with everything that the courts have requested him to comply with, and that it's over with. It's dismissed. But I think it's still going to reflect on his record the offense that he was charged with.
Okay. Ms. Hall.
Hi, Your Honor.
Hey there. Like Mr. Richardson, you were not involved with this case when it was resolved back in 2017, but you have the honor of representing the state and let me know what the state's perspective is. And you may speak for a little bit on Ms. Boyd's behalf, but I'm also happy to hear from her directly if she wants to. But tell me what your position is.
Your Honor, as you're aware, I wasn't involved in this case, but I do know that the state's position was that we wanted Mr. Handy to serve some time based on his actions in this case. That case was put up as a non-negotiated plea, and as you saw, he did receive some type of time during weekends at the county jail because he only has 1 year and 1 day left. And right now, everything in this case on our end, it's a little confusing to me. We were having issues with Odyssey this week, so I wasn't able to completely understand this disposition. I understand that there may be some conditions that haven't been met on his part. I don't want to speak incorrectly though, so I'll let Ms. Boyd or Ms. Rolak explain more of those incomplete conditions. But it's my understanding that there may be some that haven't been met. And for that reason, I would ask that the motion be denied and he just finish out the remainder of the year that's active. I understand that the other 5 years is already suspended. I would definitely object to the case getting an early termination as to follow and see with the first offender conviction and it go away now because of what happened in that case and because of how Ms. Boyd still, how she's still affected by the things that happened in this case. But again, I don't want to speak incorrectly as far as the conditions because it's civil case and criminal case, and I'm not sure how they both intertwine. It's my understanding that there may have been some conditions that Mr. Handy was supposed to complete in lieu with the criminal case, but I don't want to speak on that because I'm not completely sure. But at this time, I would ask that you deny the early termination of the case, Your Honor.
Okay, and Ms. Hall, what is Ms. Boyd's connection to Mr. Handy?
They were married when this incident happened. They were husband and wife. I believe that the divorce is final, but I'm not 100% sure, Your Honor.
Okay, so the special conditions, the sentence is a little simpler than it initially appears. There are two different final dispositions in the docket, but the only reason why there was a modified disposition entered is that I think Mr. Handy had learned more about which weekends each month made the most sense for him to go into custody. For 20 months in a row, he had to spend one weekend in jail. And because of his travel and whatnot, I think they had to change the dates that he'd spend a weekend in jail. Right. Setting that aside, the special conditions are: 1, no contact with the victim, Ms. Boyd. 2, complete a family violence intervention program. 3, don't discuss this case with the children. That says to me, Ms. Boyd and Mr. Handy have some children together, unless a therapist is present. And 4, must continue child support and spousal support. So that is the intersection of the civil and the criminal. I guess in the final divorce decree, Mr. Handy was obligated to pay child support and alimony. And I don't know the enforceability of such a provision, but Judge Downs made it a condition of probation that Mr. Handy comply with that part of the final divorce decree. And then the last thing, which really isn't a condition, was the language I read at the outset, which says not that the case may be dismissed early, but that the balance may be suspended after 3 years of compliance and completing the conditions. So what I heard Officer Crawford say is that Mr. Handy is in compliance. So I have no evidence that he has not complied. But I will tell you that the motion that Mr. Richardson filed is entitled Motion to Suspend Balance. And the relief that was asked for in the motion was to suspend the balance of the sentence. That's different from end the case early, which a judge has the authority to do, and effectively begin the record clearing process because it is a first offender disposition. Judge Downs decided that that was appropriate and gave Mr. Handy that benefit. And Mr. Richardson is exactly right. When Mr. Handy is done with his sentence, whenever that is, a judge will be presented with an order which, if signed, will remove this case from Mr. Handy's, I'll call it public record. Employers would not see it. Law enforcement would see it. A court would see it if Mr. Handy got involved with the criminal justice system again. But the IBMs of the world, if they ran a criminal history check that employers are able to run, would not see that there was this case because it's not a conviction. But it is currently an open matter, and it would show up and will continue to until the case is closed out, which is different from suspending the balance. Mr. Richardson, I'm hearing you asking for slightly different relief, which is fine since we've got everyone we need on the call. And that is not just to suspend the balance, but to close out the case so that the first offender sentence is complete. Is that, am I fairly summarizing what ultimately you're trying to get from Mr. Handy?
Yes, Your Honor, and just a brief response. I think this benefits everyone. I mean, I don't know why. I don't know why we would not want him to. I don't know why we would not want Mr. Handy to be in a position to financially take care of his children. And obviously the more opportunities he has in the business world, and the more opportunities he has to take care of his kids. He's always been, from my understanding, a very responsible father. He's taking care of his kids, and he wants to do more for his kids. So to represent that there might be some conditions that he hasn't complied with, and we don't know, we don't have any information that there hasn't been any conditions that have not been complied with. I don't know why we would not want to be in support of this. I mean, these are the kind of cases that we want to support, and that we want to send the right message to other individuals who get in trouble, that, hey, look, you do the right thing, you take care of all your responsibilities, you take care of your family, then you know what, we're going to consider an early termination of your case. So I just think he's an excellent candidate. You can see Mr. Handy, Judge, you've heard from Mr. Handy. I just think these are the kinds of cases that, and I think Judge Downs even saw that. That's why she even made this part of her order. She saw Mr. Handy. She knows Mr. Handy's case, and I just think this is the perfect opportunity to do the right thing and to close one of these cases that, we got so many damn cases in the system. Let's get some of them closed.
We do have lots of cases, but let me say this, two things. One, I did not hear Ms. Hall assert that Mr. Handy had not complied. She was very candid and repeated it several times that she thought that might be the case, but she was not wanting to wade into this, saying, I know he's done this or hasn't done that. So I didn't hear that. And the second is there may be some very meaningful reasons why people would want Mr. Handy to serve the entirety of his sentence. I haven't heard yet from Ms. Boyd or Ms. Rolak, and I want to give them a chance. You will, Mr. Richardson, get the final word as the movant, but I just wanted to clarify the nature of the relief you were seeking, because your motion that you filed is different from what I'm hearing now. Both are acceptable requests, they're just very different things. But I think I understand the ultimate relief you're seeking on Mr. Handy's behalf. So let me ask this, Ms. Rolak. Is there anything that Ms. Boyd would like you to say on her behalf, or is there anything she'd like to share with me since she has joined us on this call?
Good morning, Judge.
Good morning.
Yes, and I might have been the only person that has been with this case since the beginning. I've had a relationship with Ms. Boyd during this time, and I have spoken with her. She wrote an impact statement that I can read. But she also has some information that she would be able to give to you with regards to how she has progressed during this time.
Great. I'd like to get both. And thank you for your constancy, Ms. Rolak. It's nice to have someone who can span from January of 2017 till now. I'm glad someone keeps the same job for a little while. So why don't you share in whatever order you want. It can be the victim impact statement first, or Ms. Boyd can just tell me what it is she wants to tell me. I am ready.
I'll start first, Judge.
Okay.
Thank you for contacting me and offering the opportunity to make this statement. I am speaking today because of an incident that occurred this past Saturday, which revealed that Norman has not moved on from engaging in acts motivated to hurt me. I was extremely disturbed when the mother of the person I am romantically involved with told me Norman contacted her to engage in maligning my character to her. His decision to do this so close to this hearing causes me to think he feels confident his sentence will be suspended and he will be able to resume harassing and possibly hurting me physically again with no consequence. Initially, when Norman received his sentence for the shooting, he immediately violated his probation agreement and did not pay the child support payment due that day. He remained in violation several months thereafter. Punishment could not be enforced because his probation officer had not been assigned. He only complied after he was ordered to make his payments directly to the sheriff's office, and the threat of an arrest was imminent. Also, Norman did not pay for his children's college tuition as he stated during his plea. He needed leniency to do so, and he also did not maintain their health insurance. I have incurred those expenses. I have incurred those expenses solely. I state this because it demonstrates that he is not true to his word and makes promises to even the court that he does not honor. The events that led to Norman receiving his sentence may be final for the court, but for me, it is a constant daily struggle to overcome. I receive ongoing treatment for the PTSD and anxiety because of the shooting, stalking, harassment, and other abuses committed by him. My peace of mind has diminished significantly. I have nightmares, flashbacks, and flashbacks. I am sorry, and look over my shoulder at times when, in addition, my family and close friends were negatively impacted by the events of our marriage and his crimes. My family has a heightened level of concern and fear for my safety. They live too far to physically be a comfort to protect me. Finally, there's my children. They have grown up now, but still struggle between the love for their father and the loathe they have for his actions. They now bear the burden considering my safety when they choose to interact with him. I truly wish, but can only hope that Norman would move on and allow me to live as I have done with him. However, Norman's recent disturbing actions reveal that if you remove his fear of serving out his sentence, he will begin his cycle of terror on me again. Miche Boyd.
Thank you, Ms. Rolak. Ms. Boyd, I've got a couple questions, and then if there's anything you want to add to what Ms. Rolak just shared, you should feel free to do so. And thank you for putting those thoughts down on paper. How many children did you have with Mr. Handy? You're on mute, Ms. Boyd.
Okay, I apologize. We have 2 children together.
And do they reside primarily with you?
Yes, but they're both in college now, and when they're home, they're with me.
Okay, you mentioned in your comments that they had grown up. That was my next question. So they are college age now, and I guess are able to attend college in person, or they're doing it remotely through your place?
One in person, one remotely at my place.
Okay, well, good for them. What schools are they at?
Auburn and Bennett.
Great.
Yeah.
And are you working, Ms. Boyd?
I am.
What do you do?
I'm an office manager for a commercial mortgage banking company.
Okay. Are there things you want to add beyond what Ms. Rolak shared with me on your behalf?
I do, because I think I can give a little bit of context into the support orders and why that was a part of Norman's sentencing, which I think can help you, get a better understanding of why that was there in his history. Because at that time, I was not employed. I was a housewife, and Norman was the sole provider for our family. And after our divorce, he was physically abusive. And when he couldn't physically abuse me anymore, it became more of an economic abuse. So when he was ordered to make the child support payments or the alimony payments, he would not make them as a form of torment for me and punishment for me, regardless of the fact that my children lived with me 100% of the time. So I had been back and forth to court with him, and he had the means to pay these things at that time. Working in employment was not an issue for him. He just chose not to do it. So that is why that order was in there, because he was not paying, he was not complying. And that was the only way, I guess, as a means to try to encourage him to do the right thing. And he left the courtroom immediately after his sentence, a payment was due that very same day, and he did nothing and did not make payments for several months. And in between that time, of course, I did find work, and I'm doing a lot better financially. I'm able to take care of myself and handle the responsibilities as best I can for my kids. He does contribute, but he does not contribute what he agreed to contribute in that courtroom. I feel like it was just a ploy to get some leniency on his sentence, and he had no intention of doing so. And
Can I ask a couple questions?
Sure.
You two were divorced. The divorce was final before the shooting incident or after the shooting incident?
The divorce was final after the shooting. I filed for divorce before the shooting, and he did not sign the paperwork until after the shooting.
Okay. And as of now, so December 2020, is it your understanding that Mr. Handy is still under an obligation to pay either child support or alimony?
No, he is not under obligation anymore. The only reason he is in compliance with that is because he had well, like I said, the Cobb County Court, Superior Court judge made a ruling that he was to pay his payments directly to the sheriff because we had been back and forth in her courtroom because he remained in contempt for a majority of that time. And she wanted to know if he did not make a payment immediately so that she could have a bench warrant issued.
Okay,
So
I want to avoid dredging up too much of this because it's clearly painful for you, but I want to make sure I follow this. So you are not suggesting that as of now, Mr. Handy, he in your mind, and factually, I'm not disagreeing with you, he may not have paid everything he should have paid over time. It sounds like he was often not on time with his payments, but setting that aside, as of December 2020, there are no ongoing obligations for child support or alimony. Is that correct?
That is correct. My only concern is that he only does the things necessary when he has the threat of a consequence.
I think I understand that. You've helped me understand this. Let me ask my last question, and then you should add anything more you want. Ms. Rolak shared with us that, according to you, Mr. Handy reached out to the mother of I'm going to call it your significant other, someone you're involved with right now. Are you aware of any connection Mr. Handy would naturally have with that woman other than the fact that that's the mother of someone you're dating right now?
No, he has no reason to be in contact with her.
Okay. I appreciate you sharing that. Are there other things you think I ought to know as I'm working through this?
Yes, I would like to say that outside of that, I hope, and I really truly hope that Norman moves on and that he allows me to do so as I stated in my impact statement. Like I said, this is an ongoing thing for me. And I feel like he's done a very good job of convincing the court that he has complied. But as soon as the threat is taken away, he will resume his other behavior because that has been his behavior and history in the past.
Okay. Well, Ms. Boyd, it's very helpful to hear from you. I know it's not easy to talk about this. And it may prompt more counseling that you had to dredge all this up, but it is very helpful to hear both sides of a complicated situation. So I appreciate you plugging in this way. Thank you.
Thank you very much.
Mr. Richardson, as I promised, I want to give you the final word, and it may be that Mr. Handy wants to add something. It may be that you don't want him to add anything and you want to do the talking. But I am happy to hear from you as we wrap this up.
Well, first of all, I have no problems. If Mr. Handy wants to join in with some information that has just been expressed by Ms. Boyd that he differs with or disagrees with, I think that this would be the opportunity to do it, because I'm not totally familiar with the entire relationship with Miss Boyd and with the kids at this point in time. So, Mr. Handy, is there something you want to add at this point in time in response to what she represented, Miss Boyd represented?
Yes, I can. As she knows, my daughter and my son are my priorities, have always been. I have financial difficulties, which made me late in making payments, but I made it all up. My daughter right now is probably at my house 50% of the time. She's here. She's been here for the last week. She went home last night. My son, I pay his rent at school, take care of him. He drives my car. My relationship right now is about my kids. I have moved on also. I'm about to buy another house, get another house with my girlfriend. I have someone very significant. She has 4 kids, and I'm helping her with her 4 kids. The only reason that I was in a conversation with her boyfriend's mother, and I knew her boyfriend's mother, but before she knew him, I was in a relationship with their family before she got involved, is that she called me, and it out of the blue. But bottom line is, I have moved on also. I want the best thing to happen for her. I have complied with everything the judge has. I have not had any contact with her since we signed divorce papers. And I've moved on too. And I want her, want everybody to know that that is the fact. And with this behind me, I can better support my kids. I'm making half the money I should be making. Once this is over with and done with, then I can better support them. My daughter wants a car for Christmas. I would like to make that happen. I can't right now because I can't do that. So my bottom line is that I need to get my life back together, just like she needs to get her life back together and just move on. And that's all I'm asking the court to do right now.
Okay. Mr. Haney, I got one question for you. I was not present for your plea, so I know far less about this than you and folks who were there in January of 2017. It does not look like this was an offered plea, meaning you admitted at your plea that you fired a gun. Is that correct?
No, it was an offered plea.
Okay, that's not what it shows on the final disposition, but so you deny that you fired a gun?
No, that's correct. I did.
You did fire a gun?
Yes, that's correct.
Okay. I didn't mean to confuse you by throwing the word offered in there, that legalese, but when you entered your guilty plea, you said, yes, Judge, I did this. I fired a gun.
That's correct.
Okay, thank you. Mr. Richardson, anything you want to add to wrap it all up?
Your Honor, you've heard from both sides. I think that you understand where this case lies. I think the good thing, and I'm sorry for Ms. Boyd that she's still having uncomfortable feelings about this, but for the most part, it seems like they both have gotten another significant other in their life, and they're moving on. I just don't know how. I don't know how this does not benefit the entire family by granting the motion. And I believe Mr. Handy wants to buy his daughter a car. Well, you need money for those things. He probably wants to help out a little more in school, but it just seems like to me this is the right thing to do, Judge. And I'd beg this court to grant the motion, please.
Okay. Well, thank you, Mr. Richardson. I'm going to take this under advisement so I can think through everything that's been shared with me today. A lot of it is new since I'm new to the case. Mr. Richardson, please let your intern know we're all thinking about her. It started out with a great update on her behalf and ended with not such a great update. So a member of the bar, but dealing with some serious health issues. Ms. Boyd, I hope that you and your family have a safe holiday, and Mr. Handy, same on your side. And I really do appreciate everyone's perspective on this. This is a complicated, emotionally complicated situation. It does not involve strangers. It's people who knew each other at one time very, very well. And I'm glad you're still getting help, Ms. Boyd, with what you went through. And Mr. Handy, it sounds like you've tried to move on as well. So as Mr. Richardson said, that's probably the best part, is that you are creating new and separate lives with the shared experience of the two now adult children. And it's good that they are adults now too. All right, I will get an order out soon enough after I wrestle with this a little bit more. Ms. Hall, anything else for the state in the Handy matter?
Nothing further from the state, Your Honor.
Mr. Richardson, anything else?
Nothing else. Thank you for your time, Your Honor, and be safe, everyone.
All right. Thank you, everyone. That is it for this morning. Ms. Nelson, do we have this same feed for this afternoon? So I should keep it open?
Yes, that's correct.
Okay.